Welcome back. You're watching The Firm. Certain provisions of the Code of Civil Procedure aim to prevent multiple litigation between the same parties. Simply put, the same guys can't be fighting about the same thing in different courts. And yet, in a recent interim order, the New Delhi bench of the Company Law Board, that's the CLB, held that in such cases, parties to a dispute need not withdraw a civil suit before they approach the CLB under Section 397 and 398 of the Companies Act 1956. Aayush Ailawadi has more on this unique decision that clarifies the powers of the CLB.
Under Sections 397 and 398 of the erstwhile Companies Act, a party can approach the Company Law Board alleging oppression or mismanagement by the majority in the company, and that's exactly what Mr. Singh chose to do in this case.
Notam India is a real estate company incorporated by Mr. Singh and his brother. Both brothers were directors in the company. Mr. Singh alleged that his brother fraudulently increased the company's share capital and also manipulated the company's records. The brother also allegedly appointed his own wife as a director in the company. This prompted Mr. Singh to file a company petition under Sections 397 and 398 of the Companies Act of 1956, alleging oppression and mismanagement and conducting the affairs of a company in a prejudicial manner. What's interesting about this case is that before filing this company petition at the CLB, Mr. Singh had also filed a suit in a civil court on the same cause of action. The civil suit was withdrawn only after the company petition was filed, prompting the brother to argue that the petition is not maintainable as Mr. Singh has sought similar relief in the suit and that his interim application had been dismissed by the civil court. The brother said that due to denial of interim relief, Mr. Singh approached another forum. The brother accused Mr. Singh of approaching the CLB with unclean hands and of violating the principles of res judicata. Res judicata means a matter already judged, and the legal doctrine is well established and codified in Section 11 of the Code of Civil Procedure. Nikhil Sakhardande, who practices at the Bombay High Court, explains how res judicata bars continued litigation of cases that have already been decided between the same parties.
Res judicata is founded on public policy, and there has to be a finality to judgments, and a litigant should not be harassed again and again by vexatious claims and repeated claims. Therefore, there is this concept of res judicata which has been evolved so that there is a finality and everything is put to a quietus. Now, so far as this case is concerned, it would not apply to the CLB case, because in the CLB, what is sought to be canvassed is an infraction of shareholder rights and oppression. Even if not proven, the CLB has the power to pass any order which it deems fit. In a civil court, on the other hand, you have to make out a case where there is an infringement of a legal right. So the scope of inquiry before the CLB and the civil court being different, the principle would not apply.
That's exactly why the CLB allowed the company petition to proceed even though a suit had been filed in the civil court. The CLB also held that Order 23 of the Civil Procedure Code does not stop it from hearing the case. Order 23 says that if a plaintiff abandons or withdraws a suit, he shall be liable for costs and be precluded from filing any fresh suit in the same matter. Advocate at the Bombay High Court, Tushar Cooper, agrees that Order 23 does not bar the CLB from hearing such a case, but says that such a situation could have been an abuse of the court process instead.
In this case, cause of action is a petition for mismanagement and oppression under 398, 397 of the Companies Act, which was not the subject matter of the civil proceeding, and the reliefs which were being sought for appear to have been distinct and different from those which were sought or could be sought before the civil court. So again, I believe that the CLB was right in holding that the principles of Order 23 would not bar the Company Law Board from looking into the issue. But what was more fundamental and which the CLB seems to have omitted from consideration was the fact that, in fact, this petition was filed before the withdrawal from the civil court. Given the fact that it was filed before the withdrawal from the civil court, the question of the applicability of Order 23 would not arise. What would arise would be that in the event of a party seeking to prosecute proceedings in two different fora, it would be said that he's trying to ride two different horses at the same time, and the fora would respectively insist that he elect as to which proceeding he wished to pursue. And on the basis that prosecuting both proceedings tantamounts to an abuse of the process of the court.
Experts point out that it isn't uncommon for people to approach different fora for redressal, as Mr. Singh did in this case. Parties often approach a writ court like the Supreme Court and then also file a civil suit in another court. In such cases, the decision to entertain the case is usually left to the discretion of the court.
If a particular person files a writ, sometimes the writ court would throw him out on the basis that there are disputed questions of fact and therefore not entertain the writ. It may throw him out on the basis that there is an alternate remedy. Now, a party then on the basis of that goes and files a civil suit. He can't be told that, look, you've agitated it there. He may even withdraw his writ petition. Forget the fact that it's dismissed through the res judicata argument. He may withdraw his writ petition because he can't prosecute it there. That doesn't debar him from filing a suit. So, to that extent, yes, under different statutes, different considerations may apply. Reasons may be different for either being allowed to maintain another proceeding or from being disallowed to maintain another proceeding. You may file the proceeding and the court will say that this is tantamounts to an abuse. So it can throw it out not on the basis only of 11 or 23, it may throw it out on the basis of abuse.
Why then did the CLB not dismiss the case? Well, that's what makes this an interesting order. The CLB said that the relief it could offer was unique and hence the case shall proceed.
The CLB draws its exclusive powers from the Companies Act of 1956, and the scope of these powers is extremely wide. That's why the CLB has held that this petition is still maintainable before it.
The nature of the power that is exercised by the civil court is completely different from the nature of the power exercised by the Company Law Board. The withdrawal of the case in this case would not in any manner impinge upon the rights of a petitioner to petition the Company Law Board and say that I have been oppressed, where the nature of the controversy, the nature of the inquiry is completely different. And therefore this could proceed further in the Company Law Board.
If the question is, does the CLB order make legal sense in them invoking their jurisdiction? Answer, yes. It could perhaps have been open for someone to urge that this is an abuse, which the CLB would then consider on the facts and circumstances of the case, that this gentleman has indulged in forum shopping, that he moved the civil court, he was rejected reliefs, his suit would have been dismissed had he proceeded with it, and he therefore just at the penultimate stage seeks to withdraw it and come running here and try to initiate round 2. That is a factor which the CLB could have taken into account. But there would have been no absolute bar to the CLB maintaining the petition on the basis that a civil suit had been filed, not seeking the same reliefs and not on the same cause of action.
Although Mr. Singh's brother contended that the subsequent dismissal of the original civil suit would affect the filing of the company petition and that Mr. Singh had approached the CLB with unclean hands, Mr. Singh argued that the CLB's jurisdiction under sections 397 and 398 of the Companies Act is unique, and unlike a civil court, its orders are passed based on equity. This brings us to a key distinction relating to the jurisdiction of a court of law and that of the CLB.
Even if you have withdrawn a case from the civil court on whatever ground, without leave, without obtaining leave, because if you don't obtain leave, then the principles of res judicata apply. You can still go to the Company Law Board because the Company Law Board is not so much concerned with the legality of the issue. It is more concerned with the conduct in an equitable nature, whether it is oppressive. The civil court is concerned with the legality of the issue. What may be legal may not be oppressive, or what may be illegal can be oppressive.
It is not as if the CLB proceeds only on equitable considerations. It has to proceed within the framework of law. It is empowered to grant equitable reliefs under 397, 398, which the civil court is not so empowered. It is not that the civil court will not consider equitable considerations. In fact, the law requires that principles of justice, equity and good conscience ought to be considered, especially in cases of tort, etc. The court will consider principles of justice, equity and good conscience in arriving at its conclusion. So it is not as if equity is divorced from the civil courts and equity is only considered by the CLB. Nor can the CLB go exclusively on equity. It must take into account equitable considerations within the framework of law, and perhaps, if it deems fit, given legal sanction, can pass equitable reliefs.
The Company Law Board held that parties to a dispute are not obliged to withdraw a suit from a civil court when approaching the CLB under sections 397 and 398 of the Companies Act of 1956, since the CLB provides a unique statutory remedy that isn't available with any other forum or court of law. This case is noteworthy because it defines the scope and application of the principles of res judicata in commercial cases of oppression and mismanagement, and also clearly defines the powers conferred on the CLB by this statute. In Mumbai, Aayush Ailawadi.
And with that, we're at the end of our time on this edition of The Firm. Thanks very much for watching. We'll see you next week.